The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon to those of you in the East, and good morning to those of you in the West. It's a pleasure to meet with you again. This is a third in a series of webinars that NRRI is presenting on COVID-related rate-making matters. Just briefly, NRRI is the research arm of the National Association of Regulatory Utility Commissioners. We are here to provide service to the regulatory community, and we hope that you agree that the webinar today is going to be interesting and help us think through the kinds of issues that many of us or many of you in the state public utility commissions will be facing as we go forward. We have three excellent speakers talking about very diverse topics, but let me back up for a second. The first webinar talked about different challenges facing the industry, all of the regulated industries. The second webinar that we had in this series focused on different tools available to the regulatory community for addressing some of those types of issues outlined as challenges in the first webinar. And today we will be talking about three different types of financial challenges that the industry has gone through in the past and the kind of regulatory responses to those challenges. Commissioner Shivakula will talk about Hurricane Sandy. Mark Cicchetti will talk about the retirement of nuclear generation, and Frank Lin will discuss the financial issues around the California energy crisis. It's been a pleasure through this whole webinar series to work with Cheryl Banks, who is the chair of the NRRI Staff Subcommittee on Finance and Accounting, and who is a staff member at the Florida Public Service Commission. I'm now going to turn over to Cheryl so that she can introduce the speakers. Cheryl?
Thank you, Carl. Thank you. Our first presenter is Upendra Shivakula. He is the commissioner with the New Jersey Board of Public Utilities, where he serves since 2014. Commissioner Shivakula serves on NARUC's Telecommunications and International Relations Committees. Prior to his appointment on the board, Mr. Shivakula was a New Jersey state legislator, where he served on various committees. He chaired the Telecommunications and Utilities Committee and was vice chair of the Homeland Security and State Preparedness Committee. He's a former mayor and a former councilman. Mr. Shivakula holds both a bachelor's degree and master's degree in electrical engineering. It is my honor to welcome Commissioner Shivakula.
Thank you, Cheryl. Thank you, Carl, for inviting me. I'd like to thank NRRI for giving me this opportunity. A lot of people talk about Hurricane Sandy. Before Hurricane Sandy, in August of 2011, Hurricane Irene, which is a major water event, which has really flooded many parts of the state of New Jersey. Then followed in November of 2011, there was a snowstorm that caused 1 million outages. And so between Hurricane Irene and the snowstorm, we lost nearly 3 million outages that took place. Hurricane Sandy was a storm of the century and has created tremendous challenges to the state of New Jersey. I was not on the board at that time, but I was in the state legislature at that time. But the board did a fantastic job, and so I'm going to be talking about Hurricane Sandy and the financial impact of that. First, I'd like to put a disclaimer. I am speaking on my behalf only. I'm not speaking for the entire Board of Public Utilities in New Jersey. The first slide, the next slide, please. So when you look at Hurricane Sandy, how bad it was, and it has made the landfall in October of 29th of 2012, and it not only damaged a lot of parts of New Jersey, it also affected New York as well as Connecticut before moving on to the New England other states. Next slide, please. So some of the facts, these are because it happened in 2012. By now, a lot of information has settled down, and so we're looking at it. It's reflecting what has taken place. It was very scary for me personally. I was looking at outside of my window. I have a 50-year-old oak tree that was shaking back and forth, and it was a very scary time for us. And 71% of the New Jersey's electric distribution system was impacted. So about 5 million people lost power, and nearly 1.2 million New Jerseyans lost power for more than 14 days. And water systems, 44% of the water systems in New Jersey were without power. And trees, number of trees, Garden State, we have number of trees. We love our trees. 116,000 trees, the branches fell, the trees fell, and caused a number of outages. 100 transmission lines. Sometimes we have transmission lines on wooden poles, and especially in the central part of the state of New Jersey, where we have number of trees and very lots of beautiful landscape, and a lot of the trees came down. And when you talking about specifically about utilities, 5,000 transformers damaged because of water storm surges and other issues. And the number I put there is 9,500 utility poles. I think the numbers were even greater, because some of them were broken, some of them really tilted down. And when you have the utility poles falling on the electric transmission lines or distribution lines, they cause severe outages. And a lot of the Garden State is surrounded by water. We have ocean and we have river surrounding the state, and we had some of the substations, nearly 50 substations were impacted by flooding. Next, please. Next. So, neighboring, just wanted to, the facts and sandy facts continued. The impact, financial impact is one of the key things we're talking about. The New York Stock Exchange, affected, it closed for the first time in more than 27 years. And there were many electronic exchanges that are in New Jersey were closed for 2 days, and that has never happened before until 1888. And transportation, we have a heavily traveled corridor. We have not only the roads, but we have a lot of public transportation, and we have 3 airports. We have the 2 in New York and 1 in New Jersey, Newark. They are called the Port Authority, and 15,000 flights, more than that, were canceled. And imagine what it has done to the transportation network. And when you look at the damages, and the damages estimated to be worst in 180-year history. And of course, the trains, the buses, and the Amtrak was closed, and so stopped operating. So that way, there was no transportation. And number of bridges and roadways were closed in Manhattan. The reason I'm bringing New York is that New York is New Jersey. Some people look at New Jersey, northern part of New Jersey, as an extension of New York. So whatever happens in New York impacts New Jersey, and whatever happens in New Jersey impacts New York also. Next, please. So coming back to the utility work, right? After Hurricane Irene, the board actually came up with 103 measures in terms of the standards and how to improve communication with affected population. Also, some of the in terms of the standards we came up with, and those things continued for Hurricane Sandy. And in terms of utility expenditure, it's about $1 billion, and the expenses were close to $471 million, and capital expenditures subsequent to the Hurricane Sandy were almost $483 million. And I have provided a breakdown. PSE&G, which has a large customer base, but a lot of them are more suburban and urban areas, was not impacted as much because of it was about $247 million. And JCP&L is right in the middle of the state, where you have a lot of the rural areas and areas that have tremendous amount of trees. And really JCP&L was affected, and almost $580 million was in cost for JCP&L. And Rockland Electric, RICO, which is the northern part of the state, which is a small part of our providing electricity to state of New Jersey, they lost about $21 million. And ACE, which is Atlantic City Electric, which is the southern part, which is heavily near the shore and affected, and it was about almost $35 million for costed us. And then you have the gas utilities, PSE&G gas utility, we have almost $11 million, and New Jersey Natural Gas, about $49 million. Again, New Jersey Natural Gas has a lot of customers in the central part of New Jersey, which was affected tremendously. And South Jersey Gas, almost $11 million damaged, and so we had to rebuild that particular infrastructure. Next, please. And I just want to conclude, it is, it was only a Category 3 storm, compared to Hurricane Katrina, and but it was the 4th worst in U.S. history, and the storm surges really more than 8.5 feet, and especially at Sandy Hook Beach, which was one of the federal beaches and free beaches in New Jersey, and the total financial damage estimated because of Hurricane Sandy was $70 billion, and 650,000 homes were destroyed, and luckily we only lost 101 lives. It could have been a lot worse. But what the lessons for the utility is that we can never be prepared, and we needed to have the resilience, and resilience became a very important part. We started building microgrids and other things. So I think there are a lot of lessons that were learned because of Hurricane Sandy, and utilities are, and the board is better prepared to have the oversight over the utilities and making sure that we continue a reliable and also resilient electricity as well as gas supply to the customers of the state of New Jersey. Thank you again, and I'll be open for questions whenever it is appropriate. Next, that's it. I'm done.
Our next speaker is Mark Cicchetti. Cheryl, would you like to introduce Mark, please?
Certainly. Our next presenter is Mark Cicchetti, Chief of Finance, Tax, and Cost Recovery at the Florida Public Service Commission. He's also the current president of the Society of Utility and Regulatory Financial Analysts, known as SERFA. Mr. Cicchetti has been involved in utility regulation for over 35 years and has testified as an expert witness in numerous cases and on a wide variety of topics. He was awarded the 2019 Gerald L. Gunner Distinguished Service Award by the Public Utility Research Center at the University of Florida for his contributions to regulatory policy. It's my pleasure to welcome my distinguished colleague, Mr. Mark Cicchetti.
Mark, you are currently muted.
Sorry about that. Good day, everyone. I hope everyone is staying well. I'd like to thank NRRI for this opportunity, and to Commissioner Civicola, who gave the previous presentation, on Hurricane Sandy, we here in Florida sympathize with your experience. We feel your pain on a regular basis. Today, I'm going to talk about some financial challenges that our utilities in Florida experience and how the Commission and the utilities dealt with those. And I'm going to be talking about securitization, and I think that's particularly apt today given our experience with COVID-19, and particularly if the COVID-19 costs become substantial. First slide. Florida has done 2 securitizations. The first one in 2007 was for storm recovery costs. That was a $652 million amortization. It was over 12 years. And the second was for the nuclear asset recovery costs associated with a nuclear plant that was shut down. That was a $1.3 billion issuance and was amortized over 20 years. And the circumstances in that instance had to do with the plant, and it was undergoing maintenance and an upgrade. And they were going to have to remove a boiler associated with the steam generator. And the way they do that is to cut a hole in the containment building. And this has been done in a number of instances across the country. I know most people are familiar with the concrete containment building, and there are steel cables that run through that containment building, and they are tensioned, and they have to be detensioned, the hole cut in, take out the old boiler, bring in the new boiler. But in that process, they noticed cracks. And they fixed the cracks, and then they noticed more cracks. And then there was some, what they call delamination, where the concrete was separating from some of the other concrete. And so it was determined that in the worst case scenario, that would cost almost $3.4 billion to fix, with no guarantee that that would solve the problem. So it was determined to shut down the plant. And after extensive hearings and testimony, the Office of Public Counsel and the utility came to an agreement to allow the utility to recover $1.3 billion of costs associated with the plant. And that included an approximately $300 million haircut on the value of the plant, as well as a haircut on their rate of return. They were only going to be allowed to earn 70% of the equity return on that plant while it was being recovered. So it was determined that the best way to proceed would be to do a utility securitization. Next slide, please. Now, utility securitizations can be done for a variety of reasons, but anytime you have a regulatory asset, that's a cost that's going to be allowed to be recovered from ratepayers, and you can dedicate a stream of revenue from that plant, you could do a securitization. Most utility industry securitizations have been done for stranded costs. Back during the industry restructuring days, there were quite a few stranded costs, and over $40 billion of securitizations were done for industry restructuring. The next largest amount is for storm recovery costs, and that's only $3.5 billion, and that's been between 1997 and today. So by large, the most have been done for industry restructurings, but they can be done for a variety of reasons, as you see here. Next slide, please. Now, non-utility securitizations can be done with mortgages, car loans, and credit cards. Anytime you can package up some receivables, you can do a securitization. Now, what's important about that is the utility securitizations are much more, they're much more safe. And we're going to get into that a little bit in future slides, but keep in mind that utility securitizations, because they're so safe, should demand a better yield. Next slide, please. So what is a securitization? Well, in a nutshell, you are going to trade the utility's overall cost of capital for that of a AAA bond rate in applying that to the regulatory asset, the carrying charge on the regulatory asset. And it's very hard to achieve a AAA rating. There are only 2 companies in the country that have AAA bond ratings right now. One is Microsoft and the other is Johnson & Johnson. And in fact, the United States of America is only rated AAA by 2 of the 3 rating agencies. S&P rates them AA+. So it's hard to achieve a AAA rating. Rating agencies don't give them out easy. And what happens in a securitization is when you replace that carrying charge, the utility's overall cost of capital with the AAA bond rate, you can have substantial savings. In the case of the nuclear plant retirement, on a $1.3 billion asset, we were able to save customers $660 million on a present value basis. The utility's overall cost of capital was in the neighborhood of 6 to 7%, and the rate that we achieved on the AAA bond rating was 2.65%. And so you see that it can be of a substantial benefit to customers. Next slide, please. Now, how does a securitization achieve a AAA rating? Well, it's basically has to do with legislation and the financing offer. What you want to do is isolate and protect the dedicated revenue stream. In the case of the utility securitization, there's going to be a charge on a customer's bill that's dedicated solely to recovering the cost of that asset. And through the legislation and the financing order, we're going to remove legislators' and regulators' ability to affect the dedicated revenue stream post-issuance. So that means once it's in place, investors can continue to expect that it's going to stay in place. And in the issuance associated with the nuclear asset recovery, there was this state pledge in the legislation, and it's small letters, so I'm going to read it to you. The state pledges to and agrees with bondholders, the owners of the nuclear asset recovery property, and other financing parties that the state will not, 1, alter the provisions of this section which make the nuclear asset recovery charges imposed by a financing order irrevocable, binding, and non-bypassable charges. 2, take or permit any action that impairs or would impair the value of nuclear asset recovery property or revises the nuclear asset recovery costs for which recovery is authorized. Or 3, except as authorized under this section, reduce, alter, or impair nuclear asset recovery charges that are to be imposed, collected, and remitted for the benefit of the bondholders and other financing parties until any and all principal, interest, premium, financing costs, and other fees, expenses, or charges incurred, and any contracts to be performed in connection with the related nuclear asset recovery bonds have been paid and performed in full. And before we go any farther, where it says except as authorized under this section, that just meant there would be, if there is any alteration, that the bondholders would receive complete recovery. So basically, this pledge says the state is going to impose this charge, and it's not going to be able to change it until the bonds are paid off. And you can see how secure that makes the payment stream on these bonds. Next slide, please. So what are the mechanics associated with achieving a securitization? Well, first, a bankruptcy remote special purpose entity is going to be created. And that simply means that that entity is not going to be affected if the utility goes into bankruptcy. And I had a little note here that lawyers will take care of that. That's pretty much all you need to know. I've had a lot of experience with bond lawyers, bond attorneys. I 10 years with the state agency that issues bonds for the state of Florida, and I've come to respect bond attorneys very much. I'd like to say that they don't just wear belts and suspenders, they wear 2 belts and 2 sets of suspenders. So the special purpose entity is going to gain control of that revenue stream. It's going to be transferred from the utility. I think it's generally sold for like $1. And it's going to be the special purpose entity that issues the bonds. So although these bonds are going to remain on the balance sheet of the utility, that's required by GAAP, they're what are known as off credit. The rating agencies will not use them in determining the credit metrics for the utility because there's no recourse of these bonds to the utility. And then finally, a true-up provision is created. And what that means is that the utility, who's the servicer of the bonds, can adjust the charge either up or down to make sure that they have enough money to pay the principal and interest and associated costs on the bonds every 6 months. And the bonds are based, the charge is based on kilowatt hour sales. So the only time that there will be either too much or too little to pay the bonds if the kilowatt-hour sales are a little higher or lower than was expected. And because the conditions for the true-up state that the utility must update the charge, true up the charge at least semi-annually, it means technically it could be adjusted every month if need to be. So finally, the Commission's authority with regard to these charges is limited to just reviewing for accuracy. So if we find a mistake, the utility submits it to this Commission, and the Commission reviews it, and they find a mistake, they can make the utility aware of it. But the Commission does not have any authority, remember the state pledge, to cause there not to be enough money to pay the principal and interest on those bonds. And that's what makes securitization special. They are very safe and in very high demand with investors. Next slide, please. So how safe are these bonds? Well, we were asked that when we were doing the issuance for the nuclear asset recovery. And U.S. Treasury securities, you might not get paid if they decide to shut down the government. We know the government has been shut down on occasion, and it seems like it's being threatened more and more. And if the government shuts down, then they won't be able to make payment until the government reopens. If you're a large pension fund or a large insurance company and you don't have your money coming in when it's supposed to be coming in, that could create a problem for you. But what about the utility securitized bonds? Well, we know that we're going to keep an eye on what kilowatt hour sales are, so we make sure we have enough money to pay principal and interest. It seems like a pretty sure thing that principal and interest is going to be paid on time. So what could cause non-payment, especially for a utility with an expansive territory? And we have several of those here in Florida. If something affects their service territory, it would have to be a pretty large event in order for it to cause them not to be able to pay their bonds. For example, if you thought of the city of New Orleans and they wanted to do the securitization, if New Orleans got hit by a hurricane, that might really impair their ability to pay principal and interest for some 6-month period. But for a utility with a large expansive territory, the only two things we could come up with were nuclear war and asteroids, two things that would wipe out large amounts of their service territory. Now that we have the COVID-19 pandemic, we thought, well, could a pandemic do it? Well, I'm not aware of any utility in the country right now that's not being able to pay its principal or interest on its debt. Maybe a much more severe pandemic, I guess that would be a possibility, but it would have to be a lot more severe than we're experiencing now, and we're experiencing a pretty bad one right now. Next slide, please. So that would bring us to what would be some regulatory concerns associated with a securitization. Well, you have to keep in mind that because of the legislation, customers are required to pay the principal and interest. The normal protections you have when a utility issues a bond are not in place. For example, when the utility issues its debt, it's going to have to at some point go before the commission and justify the costs associated with that debt. And so there is an internal inherent incentive to keep costs at a minimum. When the legislation allows charges to be charged directly to customers, then someone needs to be standing in and protecting customers' interests. And that's where the commission needs a strong financial advisor, someone that has experience in the area to make sure that customers' interests are being looked at. You also want to make sure you're getting the lowest cost. You don't want a securitization to be more expensive than alternatives. For example, with the nuclear asset recovery charges, those were expected to be recovered from customers over 20 years. So when we did a securitization and amortized it over 20 years, we were basically swapping out the higher cost carrying charge for a lower cost carrying charge. But what if we decided to do a 60-year amortization? Well, maybe that all of a sudden on a present value basis is no longer the least expensive alternative. That's an exaggeration, but those are the kinds of things you need to be on the lookout for. And finally, be aware of any intergenerational issues that might occur if, in fact, you do spread out the costs over a longer period of time. So a couple of best practices to address these is to make sure that the commission does get good advice. Make sure that the commission can put in its financing order whatever is necessary in order to protect the customer's interest, and to make sure that there's a review period afterwards, that only appropriate expenses were charged. And so with that, I will just say that securitization is an important tool for both regulators and utilities to have in their toolbox, particularly if COVID-19 costs become substantial, and I will be available for questions upon the end of the presentations.
Thank you, Mark, so much. We're moving on to our final speaker today. Our final speaker today is Frank Lynn. Mr. Lynn has been a practicing attorney in the field of energy law for 33 years. Professor Lynn teaches energy law at the University of San Francisco School of Law and at UC Hastings College of Law. He is a retired general counsel of the California Public Utilities Commission. Mr. Lynn is a former president of the Western Chapter of the Energy Bar Association and is a past member of the Energy Bar Association's National Board of Directors. Mr. Lynn had the distinction of being the first person to serve as law clerk to the Solicitor General of the United States during the Supreme Court's 1984-1985 term. He also served as an appellate attorney in the Office of the Solicitor of the Federal Energy Regulatory Commission. Thank you, Professor Lynn, for sharing your knowledge with us today.
Cheryl, thank you for the nice introduction, and I also want to thank Carl Peckman and NRRI for the opportunity to speak today. And also I thank our audience, everyone who's out there listening. I appreciate your attention. My topic is a topic on something I lived through myself here in California, which is the energy crisis of 2000 and 2001. And I've kind of my introductory remark here is that I heard someone say recently that the COVID-19 crisis is the first true crisis that the Trump administration has faced that was not of its own making. And the California energy crisis of 2000 and 2001, to some extent, was of California's own making. California, to some extent, brought this on itself. So let's go to the first of my slides, please. This is an attempt on my part to capture kind of a complex legislative initiative in 1996. The remarkable thing about this California restructuring legislation was that it was enacted by a unanimous vote of the California legislature. Both the Assembly and the State Senate voted unanimously for this legislation, which brings to mind the old expression from Mark Twain, no man is safe when the legislature is in session. So everybody thought it was a good idea. And why were they doing this? I think the driver here was to get electricity prices in California to come lower, to be lower. It was a perception and it was a reality that the per kilowatt hour price of energy in California was higher than the rest of the country for a variety of reasons, perhaps. But the driver here was to try to lower those prices through a very radical, I think a fairly radical restructuring of the traditional utility companies. The traditional companies, as everyone I think knows, were vertically integrated monopolies where the utility owned the generation assets, the transmission assets, and the distribution system. Everything was monopolized in one company. The scheme here, the concept here, was to break it up and have multiple participants. The power plants, the utilities were required to sell, the California utilities were required to sell off all of their traditional legacy fossil fuel power plants to third parties. And then the other concept was that energy traders would get into this market as well. So you have power plants owned by third parties now, and you'll have energy traders coming in and selling. And again, the concept was with all this buying and selling, the prices would come down for the consumer. Next slide, please. The comment I think I would make about this is that California, in in a sense, did what you should normally do with a pilot project. You're going to try something radical and new and different. You might want to try it on a small scale, see if it works, work out the kinks, and then take it to a big scale. But California really did throw caution to the wind and restructured its entire privately owned utility industry in this legislation of 1996, which was implemented then in 1998. And as a consequence, I love this little this cartoon, but California did leave itself exposed really to two different factors. There's market forces at work, but there also was, it's very clear in hindsight, very clear that there was massive amounts of manipulation in the market by these energy trading companies and some of the power plant owning companies as well. This cartoon depicts Enron as the culprit, and Enron was indeed a culprit. Enron was involved in all sorts of manipulative activities in this restructured electricity market. But my point here is that it was not just Enron. There were dozens of these companies that were participating in the market, that were actively engaged in manipulation of the market through a variety of clever schemes to withhold capacity, to withhold product from the market, to drive up prices, and then deliver the product when the prices got high. So that was a factor, market manipulation. But also there were market forces at work. This was the summer of 2000 in particular was a very low, I think 100-year record low hydroelectric generation year for the Western United States, including the Pacific Northwest, the Bonneville Power Administration dams that in summertime typically supply a lot of very inexpensive power to California. Their water flows were way down in the summer of 2000. And so the supply of low-cost energy was really low that year. And that's a market force. That is nothing to do with manipulation. So it's really the combination of these two things that caused the catastrophe that followed, beginning in June of the year 2000 and basically running for almost a full calendar year until June of 2001. The next slide, if you would please, sort of is my attempt to capture. I used this in my law school class, but this shows you the price spikes. These are quite extraordinarily high spikes in electricity prices. There would be a similar graph that you could use to show spikes that occurred as well in natural gas prices to California. When California is short on electricity from the Pacific Northwest, the residual source that we use for generation, at least at this time in the year 2000, 2001, were natural gas-fired plants. So natural gas then becomes an absolutely critical fuel for your electricity system in a time when other sources, in particular hydroelectric energy, are in short supply. And so there was a spike similar to what you see here for the electricity market. There was a similar spike in the natural gas prices, the wholesale natural gas prices into California. So there's a double whammy for the consumers of California. Both your electricity costs and your natural gas costs are going to levels that had never been experienced. These price spikes are quite extraordinarily high. And then you'll see I drew in a circle there where it was right at that point in early 2001 when these spikes were almost at their highest point that California signed a bunch of long-term contracts. Throughout that summer of 2000 and the fall of 2000 and into the winter of 2001, California relied for its net supply of energy. The energy that was needed to meet the demand on every day was supplied by the spot market purchases, short-term purchases, hourly and daily purchases of electricity. And those were quite volatile and quite high throughout that period. And so then in the beginning in the second quarter of 2001, California signed a bunch of contracts, long-term, 50-some sellers and more than 50 contracts to essentially to kind of lock in energy prices for a while and try to curb that volatility. But the problem with that, of course, was we were locking in prices at these historically high, very, very high levels. Next slide, please. And I'm rushing through. It was a very complicated situation, very controversial and very passionately felt feelings on all sides here, but I'm going to try to give you the big picture. So remedial measures, what did California do to get itself back on track? First thing is we went to the Federal Energy Regulatory Commission. I say we, I was a lawyer at the time at Pacific Gas and Electric Company, it was later after these peak period situations that I became the general counsel of the Public Utilities Commission. But in both those capacities, I was very much involved in pursuing remedies for some of these high price situations. So at the Federal Commission in Washington, both the utility companies and the Public Utilities Commission and the California Attorney General, and then other interested parties as well, like the cities and so forth, filed complaints at FERC and said these prices are excessively high under the Federal Power Act. The wholesale prices should be brought down to lower levels, and there should be refunds of the excess charges that were paid. The FERC, I have to say, my former employer, was not sympathetic to California. FERC was, I think, viewed these as market functions. FERC was slow to recognize that market manipulation was really happening and was behind some of the spikes that we're seeing. And FERC just said it was just the market's working and the market's at work, and sometimes you have high prices, tough luck, California. We're not going to order these sellers to refund the excess. Those cases then went on to appeals. The appellate courts took a look, and in particular, the United States Court of Appeals for the Ninth Circuit here in California. They sent the cases back to FERC and said, no, FERC, you need to take a look at this. These extraordinarily high prices resulting from documented cases of market manipulation cannot be left without a remedy. We also had emergency orders from the United States Department of Energy. The Secretary of Energy signed an order, a series of these orders, beginning in late 2000, to require this. I kind of omitted a very important one of the consequences of this was that the utility companies, these great big California utilities, Pacific Gas and Electric, my employer at the time, Southern California Edison, those two big ones in particular, but also San Diego Gas and Electric Company, the utilities were threatened with insolvency. The problem for the utilities was that these exceedingly high wholesale prices were not reflected in their retail rates. The electricity restructuring legislation that I referred to in my first slide included a provision. The utilities agreed to this provision, and everyone else did too, the unanimous legislature, that froze the retail rates in the post-restructuring period. So then when the prices in the wholesale market spiked, the utilities could not recover the costs. They were in a classically bad situation. They were selling power at a loss. They were buying high and selling low. And they very quickly, within about 6 months, from June of 2000 till December of 2000, both Pacific Gas and Electric Company and Southern California Edison Company were run into insolvency, literally into insolvency, because of their inability to recover the cost of wholesale power in their retail rates. Those are healthy, strong, very large. The nation's two largest utility companies were both insolvent by the end of the year 2000. Unable to buy now in the market. The sellers would not sell to them because they're no longer creditworthy. So in PG&E's case, the gas sellers to PG&E, for PG&E's gas customers, as well as for PG&E's use as a power plant fuel, the gas sellers, just as we got into the winter of 2000, 2001, they cut PG&E off from its gas sales. And the same thing with electricity sellers and these spot sales. The sellers were no longer willing to sell to PG&E or to Edison because of the credit risk. And the Secretary of Energy, there's two sets of emergency orders that happened. The Secretary of Energy issued emergency orders under the Federal Power Act that told the sellers they had to keep selling, notwithstanding that the utilities were not creditworthy. And then I was involved directly in a petition that, because of the way the Natural Gas Act is written, the federal statute on natural gas, there was no provision in that statute allowing the Secretary of Energy to do for gas what he had done for electricity. We had to go all the way to President Clinton, and literally got onto President Clinton's desk on his last day in office in January of 2001, in which he issued a similar order requiring natural gas sellers to continue to deliver to PG&E, because we were really at risk at PG&E. The PG&E runs a massive natural gas system. We were literally running out of gas. We were pulling all our gas out of storage at that time, and there was a risk that the gas system would actually collapse because of lack of gas, lack of pressure in the high pressure pipeline system. It was really almost on the brink of a total catastrophe. We would have been cutting off entire cities from their gas supply. The power plants would have lost their fuel. We were really on the verge of a very, very serious crisis, not by natural forces like a hurricane or an earthquake, but because of a poorly thought through restructuring plan. And then the other thing California did in early 2001 was enact emergency legislation. And really the linchpin of that emergency legislation was that the state deputized its own Department of Water Resources. The California Department of Water Resources is a big electricity purchaser rather. They purchase a lot of electricity to run the state water system. We pump a lot of water in California from the north to the south. That's a big consumer of electricity. And so there are people at the Department of Water Resources who are specialized in electricity markets and purchasing, and they're sophisticated, capable people. Well, they were deputized to buy the net open position electricity for the three investor-owned utilities because the three investor-owned utilities couldn't buy it for themselves. So I refer to those long-term contracts that were signed. They were actually signed by the State Department of Water Resources, not by PG&E or Edison or San Diego Gas and Electric. And then I really appreciated the prior speaker, Mark Cicchetti's very, very informative discussion of securitization, because that is the thing California used to securitize we floated bonds, and the purchasing activity was supported by bonds, and the bonds were supported by a secure charge on the customer bill that is continuing to this day to run on customer bills for a 20-year period. It's called the DWR bond charge. So as a consumer in California, I and everybody else in California continues every single month, we have a nice little $5 to $10 charge on our electricity bill that pays off these bonds securitized by that customer charge on the bill. And with all of those various measures, and even the reluctance of FERC eventually did, I think, come around and recognize they had to impose price caps on the markets and things like that. Congress acted as well. They passed legislation giving FERC enforcement powers to provide civil penalties for market manipulators and things of that nature. So a variety of things happened that brought the prices back down, and California got on with its life, so to speak. And after the crisis period, beginning in about 2003, California recovered really quite nicely. We embarked on very ambitious programs for renewable energy, acquiring renewable energy resources through power purchase agreements signed by the investor-owned utilities whose creditworthiness had been restored. So it has a kind of a happy ending, but it was a very, very difficult, stressful period. And as I say, we came almost to the verge of having very serious kind of catastrophic human effects where people might have lost their heat and their power in the middle of the winter of 2001. So my lessons learned here, my final slide, and I chose my words carefully here because I used to work at the Federal Commission in Washington. I have many friends there. I have a high regard for the Federal Commission and many of its accomplishments. But I have to say, from the state perspective, as the former general counsel of the Public Utilities Commission, FERC was not our friend. FERC was not our friend. FERC's agenda and what it was caring about was not really the ultimate consumer and the impact on that ultimate consumer. FERC was more interested in protecting something that it conceptualized as the market. And they were unsympathetic, to say the least, to California's efforts to get refunds of these excessive charges from these wholesale sellers who were engaged in market manipulation. And we literally went all the way to the United States Supreme Court to try to teach that lesson to FERC. We had a decision in 2008 from Justice Scalia on behalf of the majority called Morgan Stanley Capital Group that really sent this all back to FERC. But FERC was not, as I say, FERC was not our friend. For the utility companies, hindsight is always 20/20, but I would say buy high and sell low. Excuse me, buy high and sell low is a very bad market plan, and it's remarkable. It is absolutely remarkable that these sophisticated utilities in California, Edison, PG&E, San Diego, signed onto a legislative package that put them at exposure, where their retail rate was frozen on the assumption that the wholesale rate would come down. And when the wholesale rate instead spiked up to very, very high levels, they were run into insolvency. So buy high, sell low. It's obvious, but it was a bad strategy. And these sophisticated companies put themselves in that position by signing on to that legislation. And then the final point I would say is just from the public standpoint, be careful when you start tinkering with the electricity market. It's far from perfect when you have the old traditional, wholly monopolized, vertically integrated utility system. It has many imperfections. I'm not here to defend it as the ultimate solution, but when you tinker with that system, be careful. Be careful, because there are unintended consequences that can happen. And as we learned really the hard way in California, electricity is a really vital human resource for health and welfare and comfort of the people, as well as for economic strength. So be careful when you tinker with that system. And with that, my final slide is to just once more thank everyone for your attention today.
Thank you, Frank. And right now we'd like to do a little bit of Q&A. So if I could have all the presenters show their video cameras on, that would be great. The first question that we have is for Commissioner Chevakula. So recognizing that you are not at the commission at this time, but perhaps you could help us and explain what you believe would be the most important lessons that utility regulators learned from Hurricane Sandy.
Commissioner is muted.
Commissioner.
Yeah, now I got it. Yeah, sorry. The basic lesson was that the utilities were not communicating well with the people, especially the elected officials and at various levels, and they were not able to get any clear-cut answers. And when will the power will be restored? And that's one of the major things. So the board released some of the communication-related rules that they put out. I think that was a very good thing. That helped subsequent storm damages. We were able to deal with that. The second thing is that a lot of the utilities infrastructure, whether it's that might be old, but it's also so close to the water, and that the storm surges really never expected that you're going to have storm surges of 10, 12 feet. And so that caused a lot of issues. So we invested, as board, invested money in trying to make sure they elevate them and working with the Army Corps of Engineers and try to come up with the proper standards. And I think those are the some of the things. And also utilities were coming for billions of dollars, and I think we had to throttle their requests, and making sure we have to balance the interests of the ratepayers as well as the utility asks.
Thank you, Commissioner. Florida had faced that same issues with customers not believing they were getting accurate information of power restoration. So that's been a big issue for us too. Mark, I've got a question here that recognizing that you're not a bond attorney, but that you've worked with so many of them. The question is, do you believe that commissions need to rely on legislation, that there needs to be statutes or legislative mandates in order to partake in securitization?
That's a good question. I know it's been said that it's not certain that legislation is needed, but I do not think without the legislation and the protections that it brings, I don't think you would be able to get a AAA bond rating, and certainly not one that's as favorable as these protections that the utility securitization bonds have deserves. So the answer is no, you don't specifically need legislation, but if you're going to do it, I would say, for lack of a better term, do it right, and let's get the lowest cost that we can, because when it comes time to sell these bonds, when you're doing the pricing, you can tend to push investors to get the best price because of these protections that come through the legislation.
And Cheryl, can I add, this is Frank, can I just add, that was California's solution as well for these energy crisis costs, was to pass legislation that basically gave the bond investors security that the Public Utilities Commission had no ability to tamper with the underlying arrangement. I think without that statutory authorization and those statutory protections, it would have been very difficult to sell the bonds.
I also, yeah, New Jersey, I was in the legislature. We also passed securitization legislation to deal with gas prices. At that time, the gas prices in 2003 or 4, after the deregulation, the board was asking them to hold the prices artificially low. And so they came back, the utilities came back for asking for securitization for the gas prices.
Charles, one other thing that I would add is when I went on the road show, we went across the country and talked to large investors, pension funds, insurance companies, and wealthy individuals. I was invariably asked the question, what if a future legislature came in and changed that legislation? And my response was, in this particular bond deal, we are saving customers $660 million. Why would the state want to shoot itself in the foot by going back on its word that it put in legislation? And I'm sure if there was some legislation to undo the ability to keep those charges sacrosanct, so to speak, I'm sure the stakeholders, the utilities, the public council, and the commission would try to inform the legislature that's not a good idea. Why would you want to take away a tool that saves customers money?
Okay, thank you all panelists for your input on that. And Mark, a real quick question follow-up was, is there a typical amortization period for these bonds?
That's another very good question. No, there's not a typical amortization period, but for example, with the nuclear cost recovery bonds, that charge was going to be collected over 20 years, and we did the bonds over 20 years. Not all of them were 20-year bonds. Although we did have an insurance company that was willing to buy the whole $1.3 billion if we would make them all long-term bonds, but that wouldn't have brought the lowest cost to customers. By working in the shorter maturities and the lower yields, we were able to get the best low cost for customers, and that's the low cost criteria that a commission should try and follow. Have your financial advisor and your attorneys make sure that all in all, you're going to get the lowest cost for customers. But securitizations can be short-term, they can be long-term. You may have the goal of wanting the lowest impact on the bill, which would mean you'd want to spread it out over the longest period of time. That might not be the most cost-effective, but if that's your goal, you can accomplish it. But overall, we'd like to see the lowest cost to customers that meets the goals of everyone involved, so you have a win-win situation.
Shifting gears here now back to Professor Lynn. Can you tell me what was the role of Enron and out-of-state energy companies in the development and passage of that California electricity law?
I think it's true that they were involved on the side of the restructuring, but I wouldn't give them a whole lot of credit. I certainly, Ken Lay, for example, was the chairman of Enron at that time, and Ken Lay was very active in Sacramento, and I'm sure lobbied for this legislation, along with other companies who were emulating the Enron model at that time. So yeah, they were influential, and they were certainly in support of it. But I don't give them the credit for enacting it. I don't think California would have gone, especially unanimously, if it weren't for this the unanimity among the utility companies and even the consumer advocates of California. There's a very effective consumer advocacy organization called TURN, T-U-R-N, the Utility Reform Network. Well, they signed on to this as well. They won't remind you about that on their website, but it had really unanimous support among consumers and the utilities and all the kind of the stakeholders in California. And so, yes, it has support from the out-of-state companies, the Enrons of the world, but it was really self-inflicted by California.
Okay.
So I would like to comment on, if I could make a quick comment. When I saw Frank's slides last night, I thought he's got this perfectly nailed. When California deregulated, I don't think, and this is just my opinion, anyone had proven that the electricity markets were not natural monopolies. And the way that a natural monopolist makes the most money is not by charging the highest price, but charging the price that makes them the most money. And the way they do that is by limiting supply. And so in California, what was happening is, oh, we're going to shut down this plant at this point in time when other things were going. And so that's how they manipulated supply, which I think is what Frank was referring to. And we saw the end result.
And if I could add one quick war story, if you don't mind, Cheryl. I was the lead attorney for PG&E on the case against the El Paso natural gas pipeline. That's not an electricity supplier, but a natural gas supplier. And we uncovered what I would call a scheme to shut down and limit the capacity of that pipeline and its deliveries to California in a deliberate effort to drive up the price of natural gas at the California border. And it was remarkably effective in that market. The prices spiked to the highest levels ever. And we were successful before the FERC in obtaining a wonderful, powerfully good decision from the chief administrative law judge that then forced El Paso to agree to a settlement in which they paid $1 billion. I'm not exaggerating, $1 billion settlement to California to the consumers. So that was a good illustration, though, of what Mark was just mentioning, where an infrastructure owner can withhold the utilization or the flow on that infrastructure in order to drive up price. And it's so important. It really is so important to have a strong federal and state regulatory structure in place to check that sort of behavior. That's why we all are here, right? Isn't that what regulation is all about? To kind of check that tendency of private monopoly money to drive up prices to the highest level they can extract.
Cheryl, may I ask the panelists one question?
Absolutely.
Yeah. What do you think about zero emission credits for the nuclear plant? So there was taken place in New York and Illinois and New Jersey. Do you look at that as market manipulation? Because they threatened to shut down the plants.
Well, it's certainly a subsidization by the customers to keep that resource in place. When it's done up front like that, to my knowledge, Commissioner, or to my opinion, I would say that is not manipulation. That is a regulatory construct that is used to, achieve a certain policy goal, namely keeping the nuclear power plants operating. I don't equate that with manipulation, because in my mind, manipulation is on the verge of a kind of a criminal activity where you do it illegal in order to drive up prices.
Yeah, thank you for clarification. Yeah, I had that question.
Commissioner Chevacula, you had in your slides that, you mentioned New York, and because it's like so close right there, one and the other. Do you know if there was any communication, any coordination between New Jersey and New York on handling some of these crises moments during Sandy?
Yeah, as I told you earlier, that I was not at the board. I am sure that my fellow commissioners, some of them were there at that time, and there was some communication, but I don't know the extent of it.
Okay.
Cheryl, may I?
Absolutely.
Mark, I'd like to ask a question, and Frank, you may have some sense of this as well. When we're talking about securitization, clearly with respect to COVID, what we're looking at are revenue shortfalls and potentially higher expenses on the part of the utility. We talked in the last session about accounting mechanisms for tracking those costs. The question that I have is, at what point, how large of a cost to put into rates should we be looking at when we start thinking about securitization? And it may vary by company size, and it may be that some companies are too small to securitize in terms of the transactions cost.
I don't know that I could give you an exact answer that the securitization should be size X. There have been some small as a few $100 million and some in the $1 billion range. Keep in mind also that some utilities would prefer not to do a securitization because they would rather keep that asset on their balance sheet and earn the return that they're going to earn. One of the big reasons that there's a difference between the overall cost of capital of the utility and the AAA cost of debt is the equity portion. And that equity portion also has to be grossed up for taxes. And so there's some utilities that have strong balance sheets that would rather keep it themselves. I mean, a lot of utilities just try to expand rate base or make investments to expand rate base because that's what increases their earnings, increases their growth. So some utilities might want to keep it on their balance sheet. if you have a situation where the utility needs the cash, because what happens when you do the securitization, the utility gets the proceeds of the bond sale, so they get their money back right away. If it's in an emergency situation, then $100 million, I'm sure you could save money by swapping out the overall cost of capital for the AAA cost of debt. And if it's a matter of keeping the bill impact small, you could do it over maybe 5 years, and where you might have recovered it over 2 years previously. But so things can be worked out. You can run the numbers and figure out what's the best for the situation.
And Carl, this is Frank. I was going to add, I really feel obligated to add that California is now implementing the securitization plan for wildfire liability costs for the utilities. As you know, wildfires are a very big problem in California, and many of them are attributed to utility infrastructure, and there's a kind of a strict liability standard in California if you own and operate that infrastructure. And so in order to allow the utilities to pay off the costs of liability for wildfires caused by their infrastructure, we have now implemented in California yet a new securitization plan of effectively an insurance scheme for the utility companies with respect to these wildfire liability costs. And the legislation that was enacted for that purpose was really just literally a markup of the 2001 legislation that I mentioned in my remarks. So here we go again in California. We're going to pay off the DWR bond charge from 2001, but it's going to be replaced by a new equivalent bond charge to cover this wildfire insurance.
Okay, Mark, there's another question here that it's saying, since the bond payments are secured by ratepayer revenue, what happens when that revenue reduces so much that it's not enough to service the bond payments? Does the state in that case guarantee the bond payments?
With utility securitizations, the utilities just raise the charge. They go through that true-up process where, based on their kilowatt-hour sales, they estimate how much they're going to need to reach that point of the principal, interest, and associated costs. Because the principal, interest, and associated costs are fairly well known, because we've got the numbers have already been run, and except if some accounting fees or legal fees might go up a little here or there, that amount might change, but it's really based on their kilowatt-hour sales. So if they sell too little in the first month of the year, they project that they're going to be low, then they would just increase the bill in the second month of the year and going forward to make sure they had enough money to pay those. And that's what makes them so safe from an investor standpoint.
And Cheryl, could I add a point there about, again, going back to California, the magnitude of the cost we were talking about for 2000 and 2001 was in the range of $20 to $30 billion. It was a very, very, very high amount of money that the state of California, with its full faith and credit, was not able to guarantee. And so the legislation specifically made it clear that the securitization was through the bond charge on the customer bill, and that the state of California was not standing behind the bonds. It would have destroyed California's credit, the state of California's credit, if it had to stand behind these bonds. That's how big they are.
Mr. Lynn, did the citizens of California actually get the refund on the gas, that the $1 billion settlement?
Yeah, I'm proud to say yes. There were a bunch of plaintiffs' lawyers who got involved. We prosecuted the complaint at the Federal Commission in Washington, and I'd like to tell my kids, and I hope to talk to my grandkids about this someday. We did the good work of the people and got that money back for the people. There were some plaintiffs' lawyers who got involved and did copycat lawsuits, and they got paid off. There's always going to be some of that activity, but the bulk of the $1 billion came back to the customers. Yes.
Okay. I think that pretty much would wrap up the questions that I have. Do any of the panelists have questions for one another?
No, thank you.
Yeah, I'd like to ask one question about stranded costs. What role the stranded cost played in your restructuring California, Dr. Lane?
There was my memory on this is not as clear as it should be, Commissioner, but yes, there were provisions in there for stranded costs, which essentially are the above market value of the power plants that were being sold off. and that was recovered relatively quickly, as I recall, in charges on the customer bills that predated the big meltdown in California. We did the restructuring in 1998, but the meltdown, as I call it, occurred in 2000, 2001. And in that interval, 2 to 3 years, I believe all the stranded costs, or most of the stranded costs, were recovered without controversy.
Yeah, in New Jersey, when they did the deregulation in 1999, there were substantial stranded costs, especially for the at that time, 4 nuclear power plants. And so that was, they were paid off, and then subsequently we paid off until, paid them off till recently, a couple of years ago. Yeah.
And in California, we kept the nuclear plants. The utility companies kept the Songs plant, San Onofre Nuclear Generating Station. It's Edison and San Diego, and PG&E's Diablo Canyon Power Plant. Those were kept in the utility companies as rate-based assets. So they were not, the nuclear plants here were not part of any stranded cost recovery.
Oh, New Jersey.
Add on to that, having been in California, working with the California Assembly during the crisis, you're correct that the stranded costs were largely recovered, but the problem with the restructuring law that you cited was that it essentially had a trigger at which point rates could not be raised until the commission determined that the stranded costs were recovered. And so there were a lot of proceedings. For example, there was a hydro asset divestiture case in which the CPUC was trying to determine the value of the hydro assets and how to credit that towards stranded cost recovery. So there was a big problem in terms of allowing the utilities to then pass on the cost of the higher price of electricity to customers, which it ultimately did. San Diego was the only utility that was able to pass on the cost to customers, which is why it escaped much of the financial hardship that the other two utilities had.
That's right, Carl. But San Diego also had a tremendous customer revolt when they saw those high charges. People were throwing rocks at the San Diego Gas and Electric Company trucks when they drove down the street. It was not a happy situation for them. Although you're right, they were not forced into insolvency the way PG&E and Edison were. That's right.
Well, I want to thank you all, and I want to thank Cheryl for her excellent navigation of the questions and keeping things moving. And I want to thank the 3 speakers that we had today. I want to indicate that our next webinar is, well, I had this show up, that we have an NRRI YouTube channel where all of the webinars will be posted. And so please help yourself to this webinar and to some of our previous webinars. And we look forward to continued involvement with all of you and with the regulatory community. And please, if you're in the audience, you have questions that you'd like to address, you can send them to us if you don't have the direct contact information, and we'll be sure to pass them on and get you the answers. Again, thank you all. Please stay healthy and safe. And we look forward to seeing you on our next webinar. Have a good day. Thank you.
Thank you, Carl.
Thank you. Thank you. Thank you.
Bye-bye.
Bye.